Hello and a warm welcome to All This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notification for new videos. My name is Sheetal Joon, Associate Editor, latestlaws.com, and let's begin with Supreme Court this week. This week, the Supreme Court has issued notices in the petition against non-uniform and exorbitant enrolment fees collected by different state bar councils. Calling it a significant issue, a three-judge bench of CJI D.Y. Chandrachud, Justice P.S. Narasimha and Justice J.B. Pardiwala has sought a response from the state bar councils across the country and has asked the petitioners to serve a copy of the petition to the Bar Council of India as well. Recently, 10 law students in Kerala challenged the same in High Court. The High Court granted them an interim relief, and later Bar Council of Kerala challenged the interim order directing it to enroll the law students with the statutory prescribed nominal fee. The BCK, in its appeal against the single-judge order before the division bench, contended that there is no statutory bar imposed on the council from levying the requisite charges to satisfy the condition of enrolment from the candidates. The Supreme Court has refused to entertain two petitions challenging Delhi High Court order upholding the validity of Agnipath Scheme and seeking to forthwith conduct common entrance examination for Indian Army. The top court said that the candidates selected in the defence recruitment process before introduction of Agnipath Scheme do not have vested rights to appointment. The petition has challenged the Delhi High Court order dated February 27th and also sought to direct the authorities concerned to conduct common entrance examination for Indian Army, for which admit cards have been issued. In a notable development, the Supreme Court has formed a high-powered committee with the process to oversee the process of verification of the degrees, certificates of advocates. The committee shall comprise of former Supreme Court Judge Justice Deepak Gupta, senior advocates Rakesh Dwivedi and Maninder Singh. The Bar Council of India will nominate 3 of its members to the committee and bench will nominate 2 from its side. The committee, constituted by 3-judge bench of CJI D.Y. Chandrachud, Justice P.S. Narasimha and Justice J.B. Pardiwala, shall start functioning on a convenient date and accordingly file a status report by August 31st. Noting that it is the duty of all genuine lawyers to get their degrees verified, the court stated that unless the same is done periodically, the administration of justice would be in jeopardy. Additionally, the court has asked all the universities and exam boards to verify the genuineness of degrees without charging fees and directed requisition of state bar councils to be processed without undue delay. The Supreme Court has asked all the courts and tribunals to consider having a uniform format and numbering paragraphs in all orders and judgments. A division bench of Justice Krishna Murari and Justice Ehsanuddin Anamullah issued directions to registrars across the country while adjudicating upon an appeal against a 2010 Punjab and Haryana High Court order which was ridden with the issue of unnumbered paragraphs. CJI D.Y. Chandrachud was part of the bench that in 2022 laid emphasis on the importance of coherent formatting, structuring and referencing. The bench had formed guidelines on judicial writing to make them easier to read. He, along with Justice A.S. Bopanna, had reserved the judgment, observed that judgment should be accessible to persons, all the sections of the societies, including persons with disability, and therefore scanned versions and not printed copies should be available. The court had opined that language of the kind in a judgment defeats the purpose of judicial writing. The Supreme Court has said that it cannot pass any order for creation of a special force to protect courts and judges, and it was for the government to take a decision and has thus sought reports from all high courts on installation of CCTV cameras in court premises in their states to beef up security. Hearing a PIL seeking creation of a special security force for the judiciary on the lines of Railway Protection Force, a bench of Justice S. Ravindra Bhatt and Justice Dipankar Gupta observed that it is for the government to take a call on. Next we have Delhi High Court. The Delhi High Court has sought a response from Bar Council of Delhi and Coordination Committee of all District Bar Association on a plea seeking enactment of the Advocates Protection Act in Delhi. Justice Pratibha M. Singh directed BCD and Coordination Committee to file a status report on their deliberation regarding the drafting of the Advocates Protection Bill. Advocate K.C. Mittal, appearing for the BCD, and stated that both bodies are in the process of drafting the bill. It was also submitted that the issue is being discussed with the Chief Minister Arvind Kejriwal, Lieutenant Governor V.K. Saxena and the law secretaries and other senior functionaries. The court thereafter passed the directions and listed the matter for 25th for further hearing. The Delhi High Court has upheld the government notification levying goods and services tax (GST) on auto rickshaws booked via app-based aggregators. The division bench of Justice Manmohan Singh and Justice Manmeet Preetham Singh Arora held that e-commerce operators such as Ola and Uber are recognized via statute and therefore the notification doesn't result in any discrimination, noting that the class of service providers is separately and distinctly Recognized in provisions of the Act having nexus with the objective, the court ruled that the notification is not violative of the fundamental rights. The notification makes GST at 5% and 12% applicable on the fare collected by auto drivers registered with the app aggregators. Uber India, in its petition challenging the notification, has argued that the government was not planning to impose any such tax on auto rides through offline modes like streets hailing, and therefore the notification were in violation of Article 14 of the Constitution. It was averred that the government failed to satisfy the test of reasonable classification and that no differentiation can be curated in terms of tax treatment between auto drivers registered with the app aggregators and those who are independent. In a significant move towards protecting the environment, Delhi High Court has taken action to prevent illegal sand mining from the banks of the river Yamuna. The court has appointed a joint task force comprising of Delhi and Uttar Pradesh police forces to combat this issue effectively. The decision came as a result of Justice Pratibha M. Singh's order, who directed the task force to regularly monitor the river banks and put in place proper pickets to prevent any illegal sand mining activity. Now let's have an overview of other high courts. The Calcutta High Court has recently ruled that a husband has right to file for divorce on grounds of mental cruelty if the wife has tried to compel him to separate from his parents without justifiable reason. The court added that it was pious obligation of the son to live and maintain the parents, adding a son living with his parents is absolutely normal in Indian culture and ethos. Observing this, the division bench of Justice Somen Sen and Justice Uday Kumar turned down a woman's petition challenging a family court's decision to grant her husband divorce. The family court had based its order on the premises that since their marriage, the applicant wife had publicly insulted the husband, calling him unemployed and a coward. In a criminal jail appeal while acquitting the accused of a double murder, the division bench of Orissa High Court noted that last seen theory in itself is not sufficient to bring home the guilt of the accused. The onus of proving the guilt still has to be satisfied by the prosecution, and it should be corroborated with the strong factors like motive. The court had concluded that there is no completion of the chain establishing its case beyond all reasonable doubts implicating the accused person, and there is no evidence presented by the prosecution to complete the chain in establishing the fatal incidents of death to have been caused by the accused appellant. It was also held by the court that there cannot be conviction based only on extrajudicial confession by one of the accused and further an accused needing to give recovery or an ornament worn by one of the deceased. The Allahabad High Court has reiterated that the power of invocation of Section 216 CRPC is exclusively confined to the court as an enabling provision, and no party has any vested right to seek any addition or alteration of charges by moving an application for alteration. The single-judge bench of Justice Ajay Kumar Srivastava observed that if there was an omission in the framing of the charge and if it comes to the knowledge of the court trying the offences, the power is always vested in the court, as provided under Section 216 CRPC, to either alter or add the charge, that such power is available with the court at any time before the judgment is pronounced. It is an enabling provision for the court to exercise the power under certain contingencies which come to its notice or brought to its notice. Remarking that suppression of or concealment of material facts is not advocacy but jugglery, manipulation, maneuvering or misrepresentation, the Jammu and Kashmir and Ladakh High Court has made it clear that the same has no place in equitable and prerogative jurisdiction. The division bench of Justice Sanjeev Kumar and Justice Puneet Gupta in this view upheld a single judgment ruling imposing Rs 1 lakh penalty on the petitioner for suppressing material facts and misleading the court to gain an advantage over the other side. The court observed that the litigant is bound to state all facts which are material or relevant to the litigation, and he must candidly state all the facts before the court without reservation. He cannot be permitted to play hide and seek and to pick and choose the facts he likes to disclose and keep back or conceal other facts. Suppression of material facts, concealment of full details of litigation present and past between the parties who are subject matter of dispute, distortion or manipulation of relevant facts, misleading the court by stating false facts or withholding true facts, this entitle a party to invoke equitable jurisdiction under Article 226 of the Constitution of India, the court ruled. The Bombay High Court, while allowing a writ petition filed under Article 226 of the Constitution of India, written with Section 482 of the Code of Criminal Procedure for quashing FIR for offences punishable under Section 406 and 420 of the IPC and consequent criminal cases pending, observed that assuming that the petitioner has received monetary benefits by selling the raw material to a third-party purchaser without paying its initial purchase cost to the respondent complainant still does not mean that there was an intention to cheat from the inception, which is the basis of ingredients of offences under section 422 IPC. Moving on to miscellaneous news. The Supreme Court is soaring under the leadership of CJI D.Y. Chandrachud to heighten its bid to achieve the inclusivity target. In the latest addition to the same, a proposal for universal gender-neutral restrooms has been approved. The top court is set to construct 9 such kind washrooms at different locations in the main building as well as in the additional building complex. This is not the only initiative the top court is advancing with. The online advocates appearance portal launched last year has also been gender neutralized, as appearance slips have modified to include an additional column where lawyers' pronouns can be added. The court is also in process of giving serious consideration to the proposal to rename the Gender Sensitization and Internal Complaints Committee to the Genders and Sexuality Sensitization and Internal Complaints Committee. A group of Indian startups has asked courts to suspend Google's new in-app billing fee system until the country's antitrust body investigates the US firm for alleged non-compliance with the directives, a legal filing has showed. The Alliance for Digital India Foundation has asked India's antitrust regulator to investigate Google for devising new system. Startups say still charge them a high service fee despite an antitrust directive in October to allow them to use third-party billing service for in-app payments. The Supreme Court has held that sales tax cannot be levied on SIM cards, recharge coupons, vouchers and value-added services like ringtones, wallpapers and music downloads, as they are not goods. Upholding an Andhra Pradesh High Court's 2011 ruling, a bench led by Justice S. Ravindra Bhatt has said that no sales tax can be imposed on sharing of infrastructures, as the same does not fall under the category of goods, a stand taken by the High Court. During the hearing of a petition challenging WhatsApp's latest privacy policy, the Attorney General of India, Mr. R. Venkata Ramani, informed a constitutional bench of the Supreme Court that a new data protection bill is ready and will be introduced in the monsoon sessions of Parliament scheduled to be commenced in July 2023. In February 2023, the Attorney General expressed concern similar to those raised by the Solicitor General earlier, stating that the court's deliberation on the draft bill may impact the debate in Parliament. He informed the bench that the bill, subject to cabinet approval, is intended to be presented in the second half of the budget session and saw the court's indulgence to postpone the hearing until then. During the Platinum Jubilee celebration of Guwahati High Court, Chief Justice of India D.Y. Chandrachud emphasized on the importance of digital inclusion and user-centric design thinking. He also highlighted the need for an ecosystem that enables the benefits of technology to reach everyone. One of the highlights of the ceremony was the launch of an app called Bhorosa, designed to ensure the safety and empowerment of women. The app enables women to send SOS messages with geolocations to emergency contact numbers, among other things. CJI D.Y. Chandrachud praised the developers for their awareness of the social realities on the ground and stressed the importance of designing a technology according to the Indian social context. The Biden administration will ask the Supreme Court to restore full access on an abortion drug after a lower court imposed a restriction on its use. The drug is used in more than half of all US abortions. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.